Hello, welcome everyone to our webinar on legal essentials for your website. My name is Nkang, and I'm a practice leader at LegalVision. I'm joined today by my colleague, McKee, who is a senior associate in LegalVision's commercial contracts and data protection team. So before we begin, a couple of quick housekeeping items. You'll be sent a copy of the webinar's recording and the slides via email after the webinar today. We also encourage you to submit your questions to us in the chat box during the webinar. And finally, please complete the short survey after the webinar, as we always appreciate your feedback. Also, you would like to know that all attendees are eligible to receive a free legal consultation with us to discuss how we can help you with your business's legal obligations under data privacy as well as technology law. So to ensure that you get your free consultation, please do request it and provide us with your contact details in the survey that appears at the end of the webinar. Moving on, so today we're going to be discussing a few important topics, and that includes how to protect your branding, how to ensure that you have watertight terms and conditions, as well as implementing your privacy policy, managing cookie concerns, and just leveraging direct marketing. So I'm going to pass on to Lauren, who will be speaking to you about how to protect your branding.
Thank you so much, Comfort. Yes, so I think the first thing we wanted to run through today is protecting your branding. Obviously, when you have a website, typically you might have a business name, a logo, and these are things that are very valuable to your business. When we think about well-known trademarks, well-known branding, we think about things like Apple, for example, or Nike. As soon as someone puts that Apple logo on a phone, they can charge 3 times as much for the phone as they could beforehand. And so much, in that same way, I guess reputation is sort of everything, and it's worth a lot of money, and so it's worth protecting your branding so that if you're pouring lots of money into your marketing, into your website, into your logos, that you have exclusivity over that and you can protect that. No one else is going to come along and piggyback off the back of your success, really, and cause confusion amongst different consumers about who you are and who your competitors are. So the best way to protect your branding is through a trademark. And what a trademark is that it's an exclusive right to your particular logo or your particular business name. Protecting your branding through a trademark can be a lengthy process. When things go well, it usually takes around 4 months, but when things don't, it will take even longer. So it's good to get started on this process early in your business's life cycle. What we always recommend, especially if you're just starting out as a business, is to conduct checks early before investing in your branding to make sure that your branding is unique. There's not other businesses out there that are going to cause you trouble along the way. And once you're sure about that, confidence that you've got a unique position in the marketplace, that's when we can look to trademark your business. In terms of once you've got that trademark, so you do have that registered right to protect your branding, that's only, I guess, worthwhile if you can use it actively to stop other businesses from encroaching on your brand. So really large businesses like Apple will have big teams of lawyers that are out there, trawling the internet to see if there's businesses trying to encroach on their branding. Obviously, that's not practical for every business, but it's important to keep your eyes peeled. And if you see other businesses out there that are trading under something similar to yours, that's when you can speak to a lawyer, issue a cease and desist letter, and try to capitalize on being the only one in the market that can use that branding. Another thing I would just recommend is just in terms of trademarking is that it is generally a country by country process. So we can register a trademark here in the UK, but that's not going to automatically give you protection overseas, say in the US. So it's important to put together a global branding strategy and see what businesses are doing overseas, because you might need to register directly into other countries. I'll keep it there for branding, but if you have any questions on that, do send them through, because we will be going through your questions at the end of the webinar. I'm going to hand back to Comfort now to have a chat through putting terms and conditions on your website and why they're super important.
Thank you very much there, Lauren. So ensuring you have a watertight terms and conditions, as Lauren mentioned there, so whether you're providing goods, services, or just digital content, you should have terms and conditions in place between yourself and your customers. So when we're looking at terms and conditions, the reasons why they're important is because they ensure that both yourself, your company, and your customers are on the same page about your contractual relationship, or what relationship you have, especially trying to understand the nature of the relationship as well as each party's obligations, really. So terms and conditions are also useful because you want to be able to refer to it if there is any misunderstanding or perhaps a dispute between yourself and your customers. So if you were to have a disagreement or a misunderstanding, it's quite easy to just go to your written terms and conditions, and it will help the parties understand, okay, this is what this page says, and then it clarifies what your intentions were. Also, it reminds you what was agreed. So terms and conditions also helps you as well in resolving conflict, but it resolves it quite quickly, and it saves costs as well, pursuing these matters outside of in court. So they also help limit your liability. So in some instances, you may want to limit to some extent your liability within the terms and conditions. So setting this out clearly is quite important. So, and the other thing as well, we always say to our clients is that once you have a terms and conditions in place that sets out information about your returns, your refunds, and things like that, it saves you time so you can focus on your business, because you wouldn't have customers on your website every day asking the same questions via your contact us site. So those are the some of the important reasons, why you should have terms and conditions. And what we also say as well is that you need to have the terms and conditions on your website if your clients can, let's say, sign up or purchase services from you through your website. So this includes, for example, if you're an e-commerce business or you're selling a subscription to your software, or perhaps you're hiring DJ equipment online to your customers, then when they're accepting the online bookings or they are signing up to the subscription, they need to see the terms and conditions whereby they're engaging and accepting the service. So for your terms and conditions to be binding, you need to make sure that the terms and conditions are put in the correct position. So you want it to be in a place on your website that's quite obvious to your customers, and you want your customers to be able to check it out, to review them before they sign up to your services or they purchase a product. Example, if you have your checkout page, what you want to do is on that page you want to have I've read and I understand and I accept the terms and conditions, and you want to have a link to the actual terms and conditions, or you want to have a page whereby they can just scroll down and review the terms and conditions before clicking checkout. So that's what we usually advise. The reason is because if you're trying to enforce terms and conditions and it's actually hidden on your website in a place whereby your customers cannot see it, then it is very, very difficult to, of course, convince anyone that the customers did in fact see the terms and conditions or read it. So as I said, it's important to have a clear set of terms and conditions, but also make sure it is not hidden on your website. Next, what is going to happen is that Lauren will touch on how you manage or additional things to include in your terms and conditions when you're dealing with consumers. So when we're talking about consumers, we mean individuals that come on your website to buy your goods for themselves and not on behalf of a business or a company. And because when you talk about those type of consumers and individuals, there are additional requirements you need to bear in mind, and the additional things you need to add to your terms and conditions. So I'll pass back to Lauren just to explain this in more detail.
Thank you, Comfort. Yeah, I do think this is a good sort of transition here, because where you are providing your goods or services to consumers, so that's the everyday person, me, I want to buy a t-shirt, I want to sign up to Netflix, the consumer laws do apply. So that's the Consumer Rights Act. And there's many things in the Consumer Rights Act, but I'll touch through a few of them. So essentially, the purpose of the Consumer Rights Act, of course, is to protect consumers. And as a business, you'll have obligations under that to help consumers be protected. So firstly, the Consumer Rights Act gives consumers certain guarantees about the quality of the goods or services that they're going to receive. So this includes that goods need to be of satisfactory quality, that they need to be fit for purpose, that they need to be as described. So for example, if you tell someone that you are going to sell them a waterproof jacket and it's not waterproof, then it's not as described, it doesn't match that. And when you're providing services, they need to be provided with due care and skill. When you don't provide your goods or services in accordance with these guarantees, then consumers do have certain rights under the Consumer Rights Act. So that's why they might come to you requesting a refund, for example, or come to you asking you to redo the services, provide them again to replace something. And so these are all mandated under the Consumer Rights Act, depending on what the actual issue is. But there's certainly certain remedies that you need to provide. And so where something's gone wrong or you've not perhaps provided your goods or services as you should, you need to visit the Consumer Rights Act and make sure that you're not in breach of your obligations by just, saying, no, I'm not going to action your request there. A couple of other key things that are super important in the Consumer Rights Act is number one is that there's certain information requirements that you need to provide to consumers when they're purchasing from you. And so these are sorts of things that you need to make really obvious when someone's signing up. So that includes what the price for your goods are, what it is that they're actually buying. If it's, say, a auto-renewing subscription, that it does, in fact, auto-renew. So what the term of the contract is. If you're a gym, for example, that's if someone's signing up to a 12-month contract, that's super clear. So there's certain information requirements that need to be in your contracts there. Other key things to note is that you need to make sure your contracts are fair. There's not unfair contract terms in there. Where you've got unfair contract terms, these are generally regarded as void and not enforceable. So some examples of an unfair contract term would be if you're trying to exclude your liability for actually providing the services. So you're still charging people when you never provide the services, or if your terms perhaps auto-renew automatically and you never tell people, you never give them a chance to opt out. The last thing I just wanted to touch on there, in addition to, of course, not excluding your liability for certain things that are sort of unreasonable, is just that in some businesses, you will need to provide a mandatory cooling off period. So that's a 14-day window where your consumers can change their mind. And that's the reason why, a lot of businesses' websites, you'll see that if you buy a t-shirt online, you should be able to return that within 14 days. Perhaps they do ask you to pay for shipping, but you should have the opportunity to change your minds there. What I'm going to do on the next slide is I've put together a checklist, and you will be sent these slides after the webinar, just for some items to run through to see if your website is compliant with regards to consumer laws. Again, this is only relevant if your business is in the B2C space. If you're in the B2B space, then this is not required. Well, some of them will be though. So number one, do you have terms and conditions in place with your customers? Do you mention those information requirements that you need to provide? Make sure your terms and conditions don't have any unfair contract terms or don't exclude your liability unreasonably. If you're required to provide a cooling off period, make sure you actually provide that, and make sure that if you've got any refunds or returns policy, it reflects that cooling off period. Ensure you've got a process internally to deal with complaints, and you've got your contact details there on the website for consumers to come to you with those complaints. And make sure that when those complaints come through that you make a reasonable assessment of them, and if there has been a breach of an individual's consumer guarantees, that you provide the appropriate remedies under the consumer laws. Another key document that needs to be on your website alongside your terms and conditions is, of course, your privacy policy. So I'm going to let Comfort now run through a bit more detail about complying with the GDPR and putting the right privacy policies and cookie policies on your website.
Thank you very much, Lauren. So on privacy policies, and I'll also touch on cookies as well, cookie concerns, not the triple chocolate cookies, but the one that is quite important when we're talking about the legal essentials required for your website. So first of all, touching on privacy policies, a privacy policy, and sometimes companies refer to them as privacy notice, is a document from your business that actually tells your consumers, the individuals, what personal data you collect from them and how you process or use the personal data. So we'll also be touching on their rights, because that's something that you should include in the privacy policy. So the GDPR, especially the UK GDPR, it sets out that you must be transparent about privacy practices within your organization, and you should also inform individuals about what you do with their personal data. So it's therefore a requirement for all businesses actually that process any personal data. So personal data can be anything ranging from the visitors to your website, their names, delivery addresses, through to their health information, or perhaps criminal records, depending on the type of business you run. So you should have a privacy policy in place. So the GDPR specifically sets out that what must be included within the privacy policy that you prepare for your business. So you should also know that the things we'll be covering, some of the things we're covering here, if you don't include them within your privacy policy, then you may be in breach of data protection laws. So it's quite important when preparing that privacy policy that you get a lawyer involved to help you, just to ensure that you've covered everything that's specifically set out under the GDPR. So moving on to the next slide, some of the key things that you need to include in your privacy policy will be information about your business. So the business name, the contact details, just so that individuals know who to contact if they have any questions about your privacy or your practices. So you also need to include information on the type of personal data you're collecting from individuals and what you use that information for, who you're going to share that information with, and how long you're going to keep it for. So individuals also have to know their rights under the GDPR, and that's one of the things you cover within your privacy policy. So when we're talking about who you're going to share their data with, generally we're thinking about what third-party companies, such as like your accountant, whereby you may need them to run the invoices for you, then you're sharing that data with the third-party accounting firm. You need to let the individuals know within your privacy policy that you'll be doing this. The other thing as well I wanted to touch on is that your business's privacy policy must be freely and easily available to the individuals that are coming on your website, such as, when you go on websites, at the bottom of the first initial homepage, you see privacy policy, so that the customer or anyone that visits your website can review your privacy policy and understand what their rights are and what data you'll be collecting from them whilst they're using your website. And you should also provide your privacy policy to individuals when you're collecting personal data from them. Example, on your Contact Us page, they're filling in their email address, perhaps their full names. And on that page, what we recommend is that you have a link there to say, review our privacy policy. This is how we're going to use this data you're sending to us. Perhaps we'll use it to contact you back. So information like that should be quite free and quite transparent, and you should have it easily available for your customers. You should also explain how you're going to handle their personal data, and that you will handle it in line with the privacy policy you're sharing with them. It just gives your customers that peace of mind to know that you don't have a different practice to what you've written within or in your privacy policy. So again, it's quite important that you have it in a very visible part of your website. It shouldn't be hidden at all. And privacy policies as well, they are live documents. So if you've been trading for 5 years plus or 10 years plus, you can't say, oh, I have one privacy policy that I prepared with my lawyer when I launched my business 10 years ago. It is a live document, and we really recommend that you review them regularly. And also, once you review them and you update them, you should inform your customers so that they know what changes you've made to your privacy policy. If you have any questions about this, please do leave it in the comment section. I'll come back to it towards the end of the webinar. So moving on to cookies. So cookies is, as I said, in this context, the text files that are placed on devices, browsers, and it actually stores individuals and website visitors' preferences. So they're used by many websites. So if you're not sure if a cookie, you're using cookies on your website, perhaps speak to your web developer. They're always a good starting point. And cookies are used by many websites, and what they use for, it can be a number of things. First of all, they can use to remember your visitors' preferences. So it records what they put in their shopping baskets, what pages on your website they're looking at, and also count how many people are looking at your homepage, for example. It can be used for advertising, so you can use it to say, oh, actually, this page is is visited a lot, so let's put more info on this page, or it helps you move around things on the website. So the other thing as well is you can use it, it's used for targeted ads sometimes. So that's why if you visit a website and they inform you of that, if they're using cookies, the next thing you can go on Instagram and you see that, oh, actually the toothpaste I was viewing on Tesco, they're now advertising it to me on Instagram. So that's cookies working there. So where you use cookies for your company, you must tell individuals what type of cookies you're using. You have to explain to them what the cookies are doing and why, and also get individuals specific consent to store the non-essential cookies on their device. So you need a consent to store that cookies on my device so that when I leave your website and go to Instagram, you can place targeted ads so I can come back to your website, or I can come back and purchase that goods that you're trying to sell to me. So that's the reason why, as I mentioned, when you go to different websites, you see like cookie pop-ups and they just follow you around. So moving on to the next slide and just touching on consent, because it's really, really important. So on the subject of consent, it has to be valid. And for consent to be valid, it must be freely given. It has to be specific and it has to be informed. It has to be quite clear so that the visitors to your website will know that actually you're asking for their consent and these are the reasons why you're asking for it. And these are what you're going to use that consent for, or once they give the consent, this is what you're going to do next. So it must involve some form of unambiguous or and a positive action. So for example, if I was to visit your website, or any of your customers was to visit your website, then having a tick box whereby someone ticks to say, yes, I've read your cookies policy, and I do give you consent to place the cookies on my device. That's good. And perhaps there can be a link whereby they review your policy and then they say, yes, I'm happy with this. I give you consent. So that is free, it's informed, I know what I'm signing up to. And what we usually say you shouldn't do is to have a pre-ticked box there to say, oh, by coming to my website, you already agree, you already give consent. No, you should have a tick box. It should be a positive action. And the other thing as well is that, again, don't hide your cookies policy within your privacy policy and put it somewhere on your website where someone cannot see it or your customers are not reading it. If you realize that your customers are not reviewing your privacy policy, do think about where you're placing it, whether it's visible, whether it's obvious to them that, look, they have to review this. And as I said, similarly, you can't just have a pre-ticked box or a pre-checked sliders. They're not adequate consent, and you can't really rely on it if you wanted to. Moving on to the next slide and touching on cookie pop-up. So as part of your cookie pop-up, you should provide detailed information about what cookies you use, which I said earlier on, and what you're doing with them and why you use them. And as I said, generally, once you visit the website, you have cookie pop-up banners, and you may have a separate cookie policy. So some companies who have one policy that contains the data privacy policy as well as the cookies policy, you may want to have separate ones. But the key thing is that they have to be detailed and they have to reflect your practices in your business, not just a general one you found on Google, because it may not, it may not be similar to the type of business you run. And that said, what I would do now is pass back to Lauren, just so she can take you through how to leverage direct marketing. And if you have any questions about cookies or perhaps privacy policy, please do let us know so we can answer it as part of this webinar. Thank you.
Thank you, Comfort. Yeah, the last thing we wanted to walk through today was using direct marketing and the laws that apply to that. Obviously, running a website using direct marketing is basically an essential these days to have a thriving business. Essentially, what email marketing is you've got lists of email addresses, you know what maybe products they're interested in, they've bought from you before, and you can use those databases to send out emails to either promote your goods and services, to offer people discounts, perhaps a softer sell by keeping people engaged in your business, keeping them up to date with news in your industry, whatever the case may be. So direct marketing doesn't just have to be via email, it can also be via text message, over the phone. I'm going to focus on emails for the moment just because of its popularity in today's world. So in terms of solicited marketing, so if someone asks you to send them marketing materials, there's no restrictions on that. So if I say, Comfort, can you please send me that brochure that we spoke about yesterday? That's fine. I've asked for it. There's no issues there. But generally, when that doesn't happen, which is most of the time, you will need to rely on consent in order to send any direct marketing materials, unless an exception applies. So much like Comfort was just explaining, we might just move to the next slide there. In order for consent to be valid, it needs to be freely given, clear and specific, exactly what Comfort just sort of ran through. So individuals must have a genuine choice of whether to consent to marketing. They should have the opportunity to say no. They need to know what they're consenting to. So if it's just very vague and it says, we might email you, that's not really specific, as opposed to, please let us know if you'd like us to email you, text you, call you about our, different offers. And then again, a positive action needs to be taken there for consent to be given. It shouldn't just be unless, by buying our services, you automatically agree. The clearest way to obtain consent is through an opt-in checkbox when at the time that someone's providing you with their email address. There are a couple of exceptions though to this consent requirement. The biggest one that I think a lot of businesses rely on is called the soft opt-in. So essentially you can send marketing texts or emails. I think this might be on the next slide. If you have obtained an individual's contact details in the course of a sale or negotiations for a sale. So what that means is that, say you are selling t-shirts online and someone provides their email address as part of purchasing from you, then that would be you're obtaining their email address in the course of a sale, as opposed to obtaining someone's email address, I don't know, at a market fair or something, where people are just signing up with email addresses. In order to rely on this soft opt-in, you need to obviously be marketing or sending emails that are similar to what it was that they signed up to in the first place. And you need to give the individuals an opportunity to opt out at the time of them providing you with their email address. So again, going back to the t-shirt example, this means that instead of saying, I consent to you sending me discounts and offers or marketing materials that might be of interest to me about your products, you're giving people a checkbox which says, please do not send me materials and discounts, etc. And so arguably, you might get more email addresses that way and more people have not opted in, but you'll have more people to email, but you do need to make sure you can achieve all of those requirements. The last thing is that every time you send marketing materials, you do need to make sure that you've got an unsubscribe functionality on your emails and that you actually action that. The last thing I will say is that it is a little bit different when dealing with corporate subscribers. So that would be business email addresses. The requirements for consent there don't apply, but I guess from a reputational perspective and a business perspective, just be careful with who you're emailing and make sure that you've got that unsubscribe functionality if you are putting people, corporate subscribers where you've got email addresses from, say, LinkedIn or websites, if you are putting them onto your email database. I'm going to leave it there and leave it to Comfort to wrap up the webinar and run through, I guess, a bit more about LegalVision while we give you a bit of time to put down any questions you've got. We're certainly very happy to answer any questions you've got as a result of the webinar.
Thank you very much, Lauren. So yeah, that concludes the main part of our webinar today. And as is shown on the screen now, you might find one of our publication, Online Business Guide, quite useful. So you can download this by just accessing the handout section in the webinar panel. It's really useful publication, and our clients find it very helpful running their businesses like yours as well. So moving on to the next slide, we do have upcoming events that may be of interest to you, and one of them is helping you and running you through the legal obligations when you're hiring staff for the first time in the UK. So it will include like how to set up as an employer. I would say it's a very useful one to attend. Even if you already set up your business or you set up as an employer already, it's probably helpful to just come along just to make sure that you've covered all the bases and you haven't missed out anything. Moving on to the next slide. So we're going to answer your question shortly, but as Lauren mentioned earlier, I'm just going to use the opportunity to tell you a little bit more about LegalVision, who we are, and how we assist you. So whilst you submit your questions to us, we'll take a minute to tell you about our membership. So LegalVision's membership is actually a cost-effective alternative to the expensive hourly rates that you experience with other traditional law firms. So how we work, for an affordable monthly fee and rate, you receive cost certainty and all-inclusive legal services. So looking at business as usual legal needs. So such as unlimited documents review, documents drafting and amending your business contracts or helping you during negotiations. Also, if you have a business premises and you wanted us to take a look at your commercial leases, that will be part of the membership. Within our membership as well, it includes unlimited legal advice consultations, and that is with our team of UK lawyers and specialists. So this includes advice on your business structuring, restructuring, employment and HR support, as well as disputes. And the great thing about it, our membership as well, is that it includes unlimited assistance with your branding, as we discussed today, as well as domestic trademark registration. So we can assist you with that. LegalVision's membership is like having your own in-house legal counsel. It's just that you don't, pay us the cost of having a legal in-house counsel, because our membership is quite affordable and it's tailored for your business and the size of your business as well. So we take care of all your business as usual legal needs, and you can focus on just running the business. And of course, if you're an in-house lawyer, in-house counsel, then you can also find our cost-effective membership useful, because what happens is that if you get quite busy, you can pass some of the work to us and we can assist you with that. So if you wanted to learn more about our membership, how we work, how we can help your business, and in particular, looking at your website and other legal needs you may have, please, I would say, take advantage of the free legal consultation as part of joining our webinar today by providing your details to us when the survey appears at the end of this webinar. All right, so thanks for listening to all that. We're just going to move on to Q&A and answer all the questions you have for us today. I will invite my colleague Hal to help us by sharing your questions with us.
Excellent. It looks like the first one that's come through is asking about trademarking overseas. So what do I do if I want to trademark overseas? So I did touch on this before, that I guess trademarking is individual to each country. So if you apply for a trademark in the UK, then you'll have a trademark in the UK, but that doesn't automatically give you protection overseas. There are two options in terms of trademarking overseas. The first is that you can apply directly to each country that you have that you operate in. Of course, that's quite practical if it's just one other country, or perhaps the EU, where you can do it all at once. But where you're applying to multiple countries, this can get, I guess, administratively burdensome as well as quite expensive. The alternative is that there's an international treaty called the Madrid Protocol, and through the Madrid Protocol, what you can do is you can actually apply to multiple countries at once. Generally, what we do is you'll have a home application, so that will be your UK application. We do that first, and then you can use that as the basis for the international application through the Madrid Protocol, and we can apply for multiple countries at once there.
Okay.
Comfort, it looks like someone's asked a question about a DPO, a data protection officer, so whether companies need one. Do you want to run through that?
Yes, thank you so much, Lauren. And also, before I touch on that, I just wanted to say, because I'll probably just answer two questions in one. So the first question would be, can we share the slides after the webinar? The answer is yes, we will be sharing the slides with you after the webinar. And thanks, Lauren. The question on the DPO, that's a very good question. So does all companies need a data protection officer, usually called DPO? The answer will be, it's not really compulsory unless your business involves carrying out large-scale systematic monitoring or large-scale processing of special categories of data, such as people's criminal records or criminal conviction data. In that case, you do need to have a DPO. But if your business doesn't do all that, then if you wanted to have a DPO, you can. But generally, we would say, as an alternative, we recommend that you have adequate or sufficient staff and skilled staff as well in place to ensure that you can carry out your UK GDPR obligations. And so that's what we usually recommend. But generally, it is advisable to have a DPO or perhaps a data protection manager, which is someone that can just take care of all your obligations and just make sure that your policies are reviewed regularly, and when they're reviewed and updated, that you can update the appropriate customers. So yeah, thanks for that question.
Okay, excellent. Another question has just come through. So if we have bought a website domain but haven't trademarked our business name, are we put at risk of another company using our name down the line, trademarking it, and then getting us to give up our business name? We are marketing services. That's a really, really good question, something that comes up all the time. So having, I guess, your name on company's house or having a domain name and owning that, certainly things that you want to happen, but it's not the same as having a trademark. And so I guess the answer there is yes, there is a risk that another business will trademark their brand, or use the same branding as you and then trademark it before you, and then ask you to stop using that domain name because they're going to argue that you're in breach of their registered rights under the UK IPO on the trademark register. What we recommend doing is getting started on that trademarking process as soon as you can, just to stop anyone else, I guess, pipping you to the post. Of course, there are times when, if you've been running a business for a long time and you can prove a lot of use, that sometimes you might be able to object to someone else's trademark application, but it's certainly the easiest route is to have that registered in your name first, and so that you can stop other businesses from trading under that brand name, and so that no one else can ask you to stop, particularly if you put lots of money into this, you do marketing services, you know what that's like. You've got that domain name, you want to keep it. I think a good example here is actually LegalVision ourselves. We many years ago, when we were first starting out, we didn't trademark LegalVision in every country around the world, but we did try, buy various domain names in different countries. And I think there was another LegalVision in France, which meant that, either the options is to not trade under that name or to enter into contractual negotiations with them where you buy the rights of someone to use that name. So it's important to do your due diligence there, and a good idea to get started on trademarking early.
Okay, Lauren, I think I'll answer the next question, which is on data subject access request. And the question is, do we have to provide all the information a customer has asked for in a data subject access request? So I think generally, to respond to this, the starting point will be what is the purpose of the GDPR? And it's there because it requires businesses to be transparent and open about personal data, the ones they have, and also respecting of the individual's rights. So with this in mind, we usually recommend that you try and supply all the personal data you have been asked to provide in a DSAR, which is in a data subject access request. And there are some instances, there are documents that it may not be appropriate for you to disclose to the other side. Talking about, example would be information including other people's personal data. So in that case, you can withhold such. But generally, if someone has requested that you share their data with them and you're not sure what data or what information to provide, it's always a good idea to speak to your lawyer about this. And we're happy to take this, outside the webinar and speak to you about it in more detail when you're using your free consultation. But thank you very much. That was a good question. Okay.
Any more questions there, Comfort?
Let's see. I think that's all we have.
Yeah, okay, excellent. Well, thank you all for the questions. It looks like there's one more. How do I get consistent marketing if I get the email address over the phone? Good question. That's also something that sort of comes up a lot, particularly if you're doing digital advertising, you're asking people to give you a call. In terms of getting consent there, you'll still need to get consent unless you can rely on the soft opt-in. So, are they actually entering into negotiations for sale with you? Even if they are, then you need to make sure you let them know, okay, we might provide you with marketing materials. Please let us know if you don't want that to be the case. The alternative is getting that consent on the phone. I've seen this done a couple of different ways. So it might be done in your voiceover that's sort of comes up before people speak to you. So, welcome to LegalVision. We may record these calls for quality control purposes, and we may, send you marketing materials. Please let us know if you don't want that. That would be one option. Or in the process of actually taking down an individual's details, asking them for their name, email address, phone number, asking them if they're happy for you to send them marketing materials. So, and when you do that, because it's over the phone there, you should still record that you've taken that consent, so that if someone questions that in the future, you can say, well, look, no, at 10:15 on Tuesday, the 21st of March, you over the phone, you provided consent, and we've got a record of that here.
Okay, thank you very, very much. Yeah, thank you very much, Lauren, for answering that last question there. So that's all we have time for today. And as I mentioned earlier, after the webinar ends, a survey will pop up. We would really, really appreciate it if you could please just complete the 30-second survey for us. And please include your contact details if you want to receive a complimentary legal consultation, as I mentioned earlier. And this will be an opportunity for you to discuss how we can help you and how we can help your company as well as your website with one of our specialists. So thank you so much for joining us today, and we look forward to seeing you in our next webinars. Thank you. Bye-bye.